So good day. My name is Mary Jane Escobar and I'm here to discuss the Module 5 in Law, Obligation, and Contracts. First, we will discuss different kinds of obligation. Section 2, Obligation with a period. So first, meaning of obligation with a period. An obligation with a period is one whose effects or consequences are subjected in one way or another to the expiration or arrival of said period or term. Meaning of obligation with a period. An obligation with a period is that there is an expiration or arrival of the said period or term which has an effect or consequences to one and is subjected or to comply one way or another. Second, meaning of period or term. A period is a future and certain event upon the arrival of which the obligation or right, subject to it, either arises or is terminated. It is a day certain which must necessarily come, or like the year 2010, next Christmas, although it may not be known when, like the death of a person. A period is a future and certain length of time which determines the effectivity or the extinguish of obligation. Next, period and condition distinguish. First, as to fulfillment. A period is a certain event which must happen sooner or later, while a condition is an uncertain event. Second, as to time. A period refers only to the future while a condition may refer to a past unknown event. And third, as to influence on the obligation. The period fixes the time of the effectivity of the obligation, while a condition may cause the demandability of the obligation to arise or to terminate. And fourth, as to effect when left to debtor's will. When a term or period is left exclusively to the will of the debtor, the existence of the obligation is not affected. But when a condition is left exclusively to the will of the debtor, the very existence of the obligation is affected. 5. As to retroactivity of effects. While a term or period does not have any retroactive effect unless there is an agreement to the contrary, a condition has retroactive effects. Next, kinds of period or term. First, according to effect, we have suspensive period or ex-die. The obligation begins only from a date certain upon the arrival of period. When an obligation is demandable after the lapse of a period, it is a suspensive period or ex-die. And second, resolutory period or in dime. The obligation is valid up to a day certain and terminates upon arrival of the period. When an obligation becomes demandable at once but is extinguished after the lapse of the period is resolutory or in dime. Second, according to source, we have legal period when it is provided by laws. And second, conventional or voluntary period when it is agreed to by the parties. And last, judicial period when it is fixed by the court. And third, according to definiteness, we have definite period when it is fixed or it is known when it will come. Definite period when it is fixed or the date and time is known exactly. And we have indefinite period when it is not fixed or it is not known when it will come. Where the period is not fixed but a period is intended, the courts are usually empowered by law to fix the same. It is sure to happen but the date and time is not known. Article 1194, in case of loss, deterioration, or improvement of the thing before the arrival of the day certain, the rules in Article 1189 should be observed. Effect of loss, deterioration, or improvement before arrival of the period. Article 1195, anything paid or delivered before the arrival of the period, the obligor being unaware of the period or believing that the obligation has become due and demandable, may be recovered with the fruits and interest. Payment before arrival of period. Article 1195 applies only to obligation to give. It is similar to Article 1188 paragraph 2, which allows the recovery of what has been paid by mistake before the fulfillment of a suspensive condition. The creditor cannot unjustly enrich himself by retaining the thing or money received before the arrival of the period. Next, debtor presumed aware of period. The presumption, however, that the debtor knew that the debt was not yet due. He has the burden of proving that he was unaware of the period. Where the duration of the period depends upon the will of the debtor, payment by him amounts, in effect, to his determination of the arrival of the period. The obligor may no longer recover the thing or money once the period has arrived, but he can recover the fruits or interest thereof from the date premature performance to the date of maturity of the obligation. Debtor presumed aware of period. The debtor has the burden to prove that he is unaware of the period that being due. The obligor may not recover what he has paid by mistake when the period has arrived, though he can recover only the fruits or interest. Next, no recovery in personal obligations. Article 1195 has no application to obligations to do or not to do because as to the former, it is physically impossible to recover the service rendered, and as the latter, as the obligor performs by not doing, he cannot, of course, recover what he has not done. No recovery in personal obligation. To do, it is physically impossible to recover what the obligor has rendered. And not to do, the obligor performs by not doing. Obviously, he cannot recover what he did not do. Next, Article 1196. Whenever in an obligation a period is designated, it is presumed to have been established for the benefit of both the creditor and the debtor, unless from the tenor of the same or other circumstances it should appear that the period has been established in favor of one or of the other. Next, presumption as to benefit of period. In an obligation subject to a period fixed by the parties, the period is presumed to have been established for the benefit of both the creditor and debtor. This means that before the expiration of the period, the debtor may not fulfill the obligation, neither may the creditor demand its fulfillment without the consent of the other, especially if the latter will be prejudiced or inconvenienced thereby. The presumption, of course, is rebutable. Presumption as the benefit of period. The contract is constructed for the benefit of both the creditor and the debtor. This just means that the debtor cannot compel the creditor to accept payment, and neither can the creditor demand from the debtor before the arrival of the certain period. Next, exception to the general rule. The tenor of the obligation or the circumstances may, however, show that it was the intention of the parties to constitute the period for the benefit of either the debtor or the creditor. The benefit of the period may be the subject of express stipulation for the parties. First, term is for the benefit of the debtor alone. He cannot be compelled to pay prematurely, but he can if he decides to do so. And second, term is for the benefit of the creditor. He may demand fulfillment even before the arrival of the term, but the debtor cannot require him to accept payment before the expiration of the stipulated period. Next, computation of term or period. First, the Administrative Code of 1987, however, provides legal periods or year shall be understood to be provides 12 calendar months or month of 30 days unless it refers to a specific calendar month, in which case it shall be computed according to the number of days the specific month contains, or day, to a day of 24 hours and night, from sunset to sunrise. Second, a calendar month is a month designated in the calendar without regard to the number of days it may contain. It is the period of time running from the beginning of a certain numbered day up to, but not if there is not sufficient number of days in the next month, then up to and including the last day of that month. To illustrate, one calendar month from December 31, 2010 will be from January 1, 2011 to January 31, 2011. One calendar month from January 31, 2011 will be from February 1, 2011 until February 28, 2011. Under the Administrative Code, a year is composed of 12 calendar months, the number of days being irrelevant. Article 1197, if the obligation does not fix a period, but from its nature and the circumstances, it can be inferred that a period was intended. The courts may fix the duration thereof. The courts shall also fix the duration of the period when it depends upon the will of the debtor. In every case, the court shall determine such period as may under the circumstances have been probably contemplated by the parties. Once fixed by the courts, the period cannot be changed by them. Next, court generally without power to fix a period. The period mentioned in the above provision refers to a judicial period as distinguished from the period fixed by the parties in their contract, which is known as contractual period. If the obligation does not state a period and no period is intended, the court is not authorized to fix a period. The courts have no right to make contracts for the parties. Judicial period is stipulated by the law. And contractual period is stipulated by the parties. Next, exception to the general rule. Under Article 1197, there are two cases when the court is authorized to fix the duration of the period. Article 1197 is part and parcel of all obligation contemplated therein. Hence, whenever the court fixes the term of an obligation, it does not thereby amend or modify the same. It merely enforces or carries out the intention of the parties. It cannot arbitrarily fix a period out of thin air. First, no period is fixed but a period was intended. The obligation does not fix a period but it can be inferred from its nature and the circumstances that a period was intended. Second, duration of the period depends upon the will of the debtor. When the debtor binds himself to pay when his means permit him to do so, the obligation shall be deemed to be one with a period. In these two cases, the court must fix the duration of the period to forestall the possibility that the obligation may never be fulfilled. In fixing the term, the court is merely enforcing the implied stipulation of the parties. In every case, the court shall determine such period as may under the circumstances have been probably contemplated by the parties. Next, legal effect where suspensive period or condition depends upon will of debtor. First, the existence of the obligation is not affected although the period depends upon the sole will of the debtor. It is only the performance with respect to time that is left to the will of the debtor. Second, if the obligation is subject to a condition which depends upon the sole will of the debtor, the conditional obligation is void because in such case, it is actually the fulfillment of the obligation that depends upon the will of the debtor. Next, period fixed cannot be changed by the courts. First, if there is a period agreed upon and it has already lapsed, the court cannot fix another period. And second, from the very moment the parties give their acceptance and consent to the period fixed by the court, said period acquires the nature of a contract because the effect of such acceptance and consent by the parties is exactly the same as if they had expressly agreed upon it. And having been agreed upon by term, it becomes a law governing their contract. However, the parties may modify the term by a new agreement. Next, Article 1198, the debtor shall lose every right to make use of the period. First, when after the obligation has been contracted, he becomes insolvent unless he gives a guarantee or security for the debt. And second, when he does not furnish to the creditor the guarantees or securities which he has promised. And third, when by his own acts he has impaired said guarantees or securities after their establishment, and when through a fortuitous event they disappear, unless he immediately gives new ones equally satisfactory. And fourth, when the debtor violates any undertaking in consideration of which the creditor agreed to the period. And 5, when the debtor attempts to abscond. Next, when obligation can be demanded before lapse period. The general rule is that the obligation is not demandable before the lapse of the period. However, in any of the cases mentioned in Article 1198, the debtor shall lose every right to make use of the period. That is, the period is disregarded and the obligation becomes pure and therefore immediately demandable. The exceptions are based on the fact that the debtor might not be able to comply with his obligation. First, when debtor becomes insolvent. He becomes insolvent after obligation is contracted unless he gives a guarantee or security for the debt. Second, when debtor does no furnish guarantees or securities promised. It means that the debtor fails to secure his debt or show collateral to the creditor. The debtor will lose his right to the period. And third, when guarantees or securities given have been impaired or have disappeared. When the security got destroyed due to debtor's fault and when it was destroyed due to fortuitous events, the debtor should replace the thing with the same value. And fourth, when debtor violates an undertaking. This when the debtor did not follow his undertaking. The right to the period will be lost. And five, when debtor attempts to abscond. This one is when the debtor tries to escape his obligation. His right to the period will be lost. So that's it. Again, my name is Mary Jane Escobar and this is my PowerPoint presentation in Module 5, Law on Obligation and Contracts.